7:03, the Crumbleys write back, and we don't know if it's Jennifer or James because they're sharing his phone. Okay. Text to the lawyers that say Marielle Shannon lawyers. Who knows why they sent that? I text, I am going to drive home from my office right now. I'll give you a call in about 45 minutes so I can get all of the bond factor information written down for you, for Marielle and me. I'm asking for bond information so we can go to the court in the morning.
Your Honor, I'm going to object. There's a prior ruling. She cannot be a witness. That was already dealt with.
Sorry, I thought I was arguing off the evidence they admitted.
Well, you can argue off the evidence.
Okay. So they say at 7:37, okay, we'll be waiting. I'm going to call in 1 minute, okay. Then at 11:14 on the phone that both of them have been using, a text is sent to the lawyers. Think we might have been found, don't know, just a heads up, please check. It's not for a couple hours that they're actually found, but Mrs. Crumbley testified she didn't send that text and she was already asleep. Now, after those text messages, there's 2 more pages that are included in that exhibit. So if you do end up taking a closer look at 4:30, which is totally fine, just be aware that there's another thread that starts that's a repeat, and I don't know why that is. I just want to let you know that, and I'm not sure why that exhibit is like that. That was a new one we got, obviously, all today. In the days after Mrs. Crumbley and Mr. Crumbley are planning to turn themselves in, we know they're planning to turn themselves in because Exhibit A was admitted, which showed they were trying to find a hotel in Auburn Hills on Priceline for December 4th and 5th in case they needed it for the weekend. There's no doubts, and I don't need to go on and on about this, they were getting threats. That was so clear at trial. They were afraid to go turn themselves into a police station. A police station where if they went, there would likely be other inmates or bad people there, and their faces would be up on a TV because it was all over the state at that point. They were terrified. They wanted to go in through a lawyer. Reasonable doubt can be inferred from the fact that they set an alarm clock, which was admitted by the prosecution, showing that on Saturday they were getting up at 6:30 or 6:45, completely consistent with their plan to go to Novi for an 8:30 hearing. This is also not James's trial. I am not standing here suggesting that James is guilty of involuntary manslaughter in any way, but it is important to point out that James was the parent responsible for all of the storage of the guns. Jennifer Crumbley barely knew a thing about them. She didn't object to them being in the house. She didn't object to buying the gun that James and Ethan were interested in. She didn't object to calling it Ethan's Christmas gift. She was not responsible at all for the storage of the weapon. It is misleading to suggest by the prosecution that that Sig Sauer case was open on the bed and that it sat open like that all day with the ammunition box next to it. It's very clear that when James and Jennifer Crumbley were on the phone during that 7-minute phone call, Mr. Crumbley was looking for the gun, found the gun was missing, asked Jennifer Crumbley, where's the ammunition, pulled it out, and set it on the bed. It's not like that gun box, that case, was just sitting out there open at all times. When law enforcement did get there, find it on the bed, even they moved it around to the kitchen counter and other places. While this is not James's case, it is fair that Jennifer Crumbley would expect that he would have more flexibility in going to handle an issue at the school. That is not unreasonable and does not make her a bad mom. He's out in the Oxford, Lake Orion, Rochester area door dashing She's the one with the professional career supporting the family and paying all their bills and trying to keep her job, which they may need to add the family on for insurance in this open enrollment period. She shouldn't be diminished as a mother because she was going to let father go to the school and handle whatever. Now, ultimately, they went together. But he's a DoorDash driver. She's trying to pay the bills. She's the breadwinner. At that time, he's in between jobs. She shouldn't be dinged for that. It's misleading for the prosecution to suggest there's been evidence in this case. She keeps guns in the car. She didn't say she keeps guns in the car. When she was interviewed, and if you really want to watch the interview, you can, Jennifer told law enforcement there was one time that gun was in the back of her car. That one time was when James put it in the back of the car, and she drove the car to the range. Her son and her had a experience at the range, and she drove the car back home, left the car locked with the gun in it, so that when her husband got home, he could put it away. It is not true that she was driving around keeping guns in the car. That is not what she said to police. As far as Mrs. Crumbley knew, there was a cable lock on the gun at all times. She called it a string lock. She testified that the key was kept in a separate place in one of the many beer steins they had. She testified that she did know where the ammunition was. She hid it in her drawer of jeans. And she testified that things were locked and hidden separately, and that Mr. Crumbley was responsible for hiding the weapon. If you are upset with how the weapon was hidden, that's not your issue to decide. That's a future jury that will look at the case of James Crumbley. You're here to look at the case of Jennifer Crumbley and consider what she knew. She is not the person responsible for storing this weapon. I'm not trying to suggest she didn't know it was in the house, but she is not the person putting the cable lock on and off or doing anything with the gun. We saw her gun abilities when she went to the range and had to have her son show her everything about it. It's a gross overstatement to keep saying that the gun was his gift. It's very clear it was something bought for him to use at the shooting range, something that may one day ultimately be truly just his. But it's just like any of us giving our kids a laptop to use, a cell phone to use, a car to use, a jet ski. I have a friend that has kids, they have snowmobiles. Nothing different. It doesn't really mean the kids just have free access to all of that stuff. It comes with conditions, rules, and parameters. Unfortunately, this is a case where the prosecution made a charging decision way too fast. It was motivated by obvious reasons for political gain and media attention. And we know that because on 11/1, when the shooter was arraigned, the shooter was on Zoom, and so were the parents, and the media was aware. And when Mr. and Mrs. Crumbley were charged, and there was a swear-to at the court, the media was all there, but guess who wasn't? Mr. or Mrs. Crumbley. Mrs. Crumbley testified she didn't even know there was going to be an arraignment, but the media knew. And then the prosecution came out with a big press conference, announcing it. I would submit that the plan was never to let the Crumbleys turn themselves in, but to turn them into a big charade of looking like they're trying to flee when they absolutely weren't. The prosecution and law enforcement have approached this case with tunnel vision from day one. Brian Maloche called it a witch hunt. I would submit to you it was. And once they charged these parents and the ATF, Sheriff's Department, Border Patrol, Secret Service, all U.S. Marshals, not Secret Service, when all these agencies have gathered around and hundreds of people are looking for the Crumbleys, it's really hard to say, we made a charging decision a little too fast. And in this case, you heard evidence that much of the evidence in the case didn't roll in until after the parents were charged, arrested, and in jail. To try to suggest having multiple phones as a sign of fleeing is just garbage. I think everyone here clearly understands why they bought burner phones and why they went and bought replacement phones with their phone numbers so they could use two-factor authentication to get into their accounts. Jennifer Crumbley is seen in the police interview at the substation handing her phone to law enforcement when they're asking questions. When the police tell her they want to take her phone for a search warrant, she doesn't want to hand it over right away, but it's not because she's trying to hide things. It's because it's her only line of communication. She doesn't really understand how a search warrant works until her husband explains it. All of her contacts are in the phone. She doesn't carry around a little diary of all the numbers, although police do let her get the numbers out. And it's the only way people can get a hold of her, and she's been in touch with them nonstop, as we can see when she's in the police vehicles. And again, although she's on her phone, and there's a substantial amount of time where she's looking things up, communicating with people, trying to get things done, that doesn't mean she believed her son was a school shooter and had no emotions over what was happening. The prosecution has painted her out to be a person who lacks remorse, and I would submit to you that she would change everything if she could. And when she looks back and says there's not a thing that she feels she could have changed that would have changed something, you have to keep in mind that the suggestions by the prosecution are just ridiculous. Giving him a hug that day in the counseling office was going to stop a mass shooting? That's just ridiculous. There is nothing to prove that anything could have stopped a mass shooting when you're dealing with someone who is so manipulative and is a criminal and was a shooter in cold blood and pled guilty and took responsibility as an adult for his crimes.